I wouldn't want them to have to sit through the lines at 4 a.m. and all that stuff. But we were ready. We were ready sad because I would have told them, oh yeah, you should have to show up at like 6 a.m. I was really hating myself. Felt pretty good.
That's extra credit.
Yeah, there were. They continue to wrap around.
I'm actually watching this.
Oh, good. That's the one I was just thinking about. So glad you wanted me on that.
Good. I'll let you work on that.
So I apologize for my tardiness. I'm the one setting up this event, but I had to wait a long time. Extra for delivery, but I'm going to go grab the plates and everything, but I'll be right back before the event starts, okay?
Yeah, exactly.
We'll get you that.
Make a difference.
I'm going to talk to Lisa.
Yes.
Right on forward.
This was Lisa through her former clerk, who was in Georgetown. It was in my mind.
I was worried. I realized that as a Native American,
I never spend the weekend reading. Right.
I just know that it exists.
One step. I know.
Yes.
There were a lot of people out, so it took me a minute to remember all of the groups. So I thought that's good. That helped.
All right, that's what I was
Someone told me the perfect replica of the situation where the Attorney General was also yeah.
There were more congressional views than I thought. We got a brief from Four Horsemen hiking. I think there was anything
see someone as a diagram. It's like, if it's that important to you, there's no direct mechanisms for resolving this. Yeah.
Hi.
They're bringing the guy who was setting up. It's a little late.
I don't know, we can just like order that.
Hi everyone. Welcome. Thanks for doing this. I hope you didn't have as much trouble as I had getting here. We'll take after Eric.
Oh, you mean finding the actual room?
Well, no, I mean finding the entrance.
The building was easy.
I walked that building.
Right.
Swinging doors or whatever, everything going through that one.
They checked
Yeah, there's signs and stuff, all of us were first, and so I chose to go right instead.
Oh, yeah.
I chose right.
Right.
I got your
I got your choices. So well, let me just sit in the library for a while.
No, the one facing.
Zero traffic. Coming all the way from Georgetown, so you just never know. So I made sure the way I'm gonna be late, got my lift heel early, and then got here and I was like, 45 minutes. Just thinking stuff right
For a while I had a Georgia.
So we're not breaking score. Yeah, true. Almost always bring work with me anywhere I go, just in case I'm sitting around. Right. Of course,
because, like, that looks like some sort of hard times, but I wouldn't have any issue.
Isn't it bad?
Yeah.
So I don't discourage anyone from sitting in the front row. Stuff in the way.
No one will sit in the front row.
It's impossible.
Oh, yeah.
What's up, man? What's up, council? Sorry.
I'm excited living in Richmond. It's 3:15. Wake up to get up here, so I just chug some coffee. So either I will be hopped up or it will not take effect, and I'll just slam my head on the table falling asleep.
Our CEO. Apparently, he usually takes Amtrak. Apparently, those are all contributors.
Oh, really?
He drove.
So that's another reason I drive is working.
There's a problem. I hope it's a railway issue, not something.
Right. I have some of these when I get home. And really unreliable. The car is more effective. It should take an hour and 45 minutes to do that. It's here at 8. There's nothing in the way or anything like that. But on the way back, they're kind of they're always delayed for some reason. Yes, yeah, I do. So I usually spend 2 days a week in the office. I'll just drive up before at 3:30 in the morning and then spend the night and drive back the following night. It's actually not a bad gig. Oddly enough, I see my kid more this way than over the Yes.
But you have to go to the rigid schedule.
Right.
Lisa Sornin, Eric Citron, what's the difference?
I leave before they got there. I saw them wait. 9, 6, 6,
Are you now staying and being here for it?
No, I'll leave as soon as I'll grab a sandwich. I'll have to be speaking at 1. This group that I like guarded myself to I gave them my office space. I've done everything for them, but I asked them, could you please change my time? They give me a day and a half, but could you please change how I speak? No. So, and the whole thing, yeah, it's ridiculous. There's another meeting that's ending with the International Municipal Lawyers Association. I spoke to them at length on Friday. So like it had to be 12 appellate stuff mostly. So it had to be like 12:30 a day so they could come over here. So I couldn't negotiate on this
You
side.
probably should get a little bottle of water just in case.
Maybe I have a black pen. Maybe I at least have that.
Should we like be organized in a particular way to get this like on?
And David, do you want to
Is it on like, will I cover all of it?
Is it being video or just, this is the review we're doing, it's live, and then the captions get added later? There's a lot going on.
It will like get the whole thing.
It sort of seems hard to believe, but that's.
It may be that it's all remote controlled and someone
It could be, right.
adjusts it when people speak.
I think it's something from George Washington.
You can have a spare pen, would you, Lisa? Oh, you did. Oh, thank you, Dave. I appreciate it. Rushing out of the office.
Did you want water, iced tea?
I got my most important caffeine. Poor things.
All right. Plugging away. How are things on your end?
Same thing. Plugging away is definitely what it's all about.
Yeah. Keeping busy, which is something that you definitely have to be happy about. And, just, my clinic is going well. Though admittedly, we're looking at transitioning it pretty soon. Yeah, I mean, it's so much work. I call him my idiot friend now. He was one of my section mates in law school, and coincidentally, I went to Mary. He made a mistake last week. Tell me how much time you spend on the clinic. And he's like, oh, I don't know. I tried to make this for you. He made me add it up, and I was just like, yeah, I can't justify this when it costs me as much money as it costs me, and it keeps me away from my kids as much as it does. So I told him, yeah, I'll do another year or two, but either we split this thing up or we're going to have to find something else.
Well, you figure, you're doing, in our case, about 12 plus your teaching, plus your travel.
Exactly.
So people want to know how to do that.
Right. Exactly. It adds up real fast. And I spent 5 years doing it without, trying to make sure I didn't know how much that was, because I knew it wouldn't be a good number.
No, and it's also, I mean, look, you've got an established practice. It's a lot easier for somebody else. Right.
So if I spent half that time in practice development and half that time with my kids, I'd be able to pay for all the soccer and ballet and help coach the soccer.
No, well, the kid thing is definitely a big deal. So I think by the time I started, our oldest just had graduated from high school.
We have multiple details.
Didn't want to talk to you anymore anyway.
Yeah, well, the oldest was gone. Well, the younger one was a girl, so she wanted to talk to, choosing between me and her mother at that age, I was much more preferable. Everyone's happy now. 10 years later.
I think we'll be in a similar boat with our kids. We got 4 girls, and I think they will want to hang with me more.
Dad, it's magical.
Yeah.
There's nothing you can do. As I keep saying to Laura, I didn't choose this. It's just nature.
She is cooler than I am, so there's that. They'll look to her for fashion.
We don't know if we're camera phone.
What is that?
But honestly, don't have to do anything, so please sit down, feel comfortable. Do you want a water?
No, I have my
We get away. Sort of appropriate.
Stand next to me. Or like I make the omnipresent.
These are not the kind of chairs where people come around to shrink you at night.
I always put them down on the ground. Sit between
Your shadow. Good afternoon, everyone, and welcome to the State and Local Legal Center and the Native American Law Student Association's panel on South Dakota versus Wayfair. I'm Lisa Soden, Executive Director of the State and Local Legal Center, and I thank you all for being here. It's now my pleasure to turn the conversation over to David Parkhurst from the National Governors Association.
Thank you, Lisa. Good afternoon, everybody. I really want to encourage those here in the room to make certain that you get lunch and water and be ready for a very engaging panel today on South Dakota versus Wayfair, which is possibly one of the Supreme Court's most consequential cases this term. And as we were talking before the session, if you realized last Tuesday when a lot of us said we could get there by 7:30 and we'd get into the courtroom, we were wrong. And we will discuss the implications of the consequences of this case as we go forward here. My name is David Parkhurst. I'm General Counsel for the National Governors Association. And for full disclosure, NGA has been involved for years in the multi-front effort to resolve whether states and local governments may require remote sellers to collect and remit sales taxes on transactions from in-state buyers. NGA for years has been a leader both on the legislative front with Congress, but we've also served as amici on behalf of states and governors in matters before numerous state and federal courts. In South Dakota, NGA joined with other national associations that represent state and local elected and appointed officials on an amicus brief on behalf of the State and Local Legal Center in support of petitioner. And again, for those of you that were here at the outset, Lisa Sornanen is the executive director of the SLLC. What is this case about? What is South Dakota versus Wayfair? Well, the Supreme Court may finally answer, depending on how you see the case, a 51-year-old question or a 26-year-old question, whether states and local governments have constitutional authority to collect taxes due on sales transactions between buyers and remote sellers that don't have a physical presence within where the buyer lives. Last Tuesday, the court heard oral argument. South Dakota is asking the court to overturn its 1992 decision in Quill Court versus North Dakota. The Quill Court held that, absent congressional approval, states and local governments may impose tax collection obligations only on retailers with a physical presence within their borders. In 2016, the state of South Dakota enacted a law that required remote sellers that met certain metrics on minimum contacts based on sales to in-state buyers to collect and remit sales taxes on those transactions. The state's high court struck down the law, as expected, because it violated Quill's physical presence standard. The state then petitioned the Supreme Court to hear the case, and the court accepted. A central question for the court in today's golden age of internet shopping is really what constitutes nexus? Is it the physical presence standard, or is it economic presence? For remote sellers, especially those that are small, mom and pop sellers, the issue is rooted in the due process clause, because without the nexus of physical presence, there isn't a connection with the taxing jurisdiction, unlike a Main Street retailer who has a voice through the ballot box, through access to their local elected officials. Conversely, for states and local governments, under a 41-year-old court decision that established a four-pronged test to determine the validity of any state's tax laws, a state tax adheres to the Commerce Clause if it's applied to an activity with a substantial connection or nexus with the taxing state. States and local governments argue that an applicable activity is selling a product or service to a buyer in another state. But let's strip this down because the clock is ticking. Because of Quill's physical presence standard, states and local governments for years have essentially left sales tax revenues from E Street retailers, but not Main Street transactions on the table uncollected. We can discuss that going forward. Today we're going to discuss the legal arguments surrounding the case with 5 esteemed practitioners. And it's a very special panel because everybody today was involved in one way or the other with South Dakota versus Wayfair. Tillman Breckenridge to my left, with Bailey Glasser, concentrates on appellate litigation at all levels. Additionally, Tillman is an adjunct professor of law at William & Mary Law School, where he directs the school's appellate and Supreme Court clinic. In South Dakota versus Wayfair, the clinic, led by Tillman, drafted the amicus brief on behalf of the State and Local Legal Center in support of respondents. At the end, we're joined by Eric Citron, a partner with Goldstein & Russell. Eric concentrates his practice on appellate litigation at all levels. He's also a regular contributor to SCOTUS blog. In South Dakota versus Wayfair, Eric represented the state as counsel of record throughout the litigation. Now, Eric is clerk for not one, but two Supreme Court justices, Justice O'Connor and Justice Kagan. Prior, Eric served as an assistant AG in the Justice Department's Antitrust Division, and he was also in private practice at WilmerHale. To Tillman's left is Erin Murphy, a partner at Kirkland & Ellis. Erin's practice focuses on appellate and constitutional litigation. She's argued 4 cases before the Supreme Court, including successfully arguing McCutcheon versus FEC and successfully arguing on behalf of the United States House of Representatives in Texas versus US. In South Dakota versus Wayfair, Erin drafted an amicus brief in support of respondents on behalf of a group of interested parties, including, for instance, the National Taxpayers Union Foundation. And to Erin's left is Andy Pincus, a partner with Mayor Brown. Andy focuses his wide-ranging appellate practice on the US Supreme Court, where he has argued 27 cases, and in federal and state appellate courts. He's also developed legal strategies at the trial level and presents policy and legal arguments both at the legislative level before Congress, state legislatures, and regulatory agencies. Andy is a former assistant to the US Solicitor General, and he too co-founded and serves as co-director of Yale Law's Supreme Court Advocacy Clinic. In South Dakota versus Wayfair, Andy drafted an amicus brief in support of respondents on behalf of eBay Incorporated. And finally, we have Deborah White. Deborah is the Senior Executive Vice President and General Counsel for the Retail Industry Leaders Association. Deborah oversees RILA's corporate legal, compliance, and litigation responsibilities. She also serves as president of the Retail Litigation Center, which acts as the voice of the retail industries in the court. Now, in South Dakota versus Wayfair, Deborah led RILA's amicus support for the petitioner, including coordinating a comprehensive team of public and private sector amici. So to our panelists, thank you very much for participating today, and let's get going. Now, each of you was either in the courtroom, you either read the transcript or both. Now, setting aside for now speculation about the likely outcome, I want to get a read from you all on what was the most important takeaway from oral argument. Let me start with Deb.
Sure. Well, thanks very much for having me. A great panel that you've assembled here. The retail community, we represent the traditional brick and mortar retail community, and they see the current situation as the court's existing cases as imposing sort of great unfairness because they disadvantage one type of commerce at the benefit of another type of commerce. And I guess there were 2 things that really struck me about the argument. I mean, one thing that's a little bit unusual about this case was we knew going in where 3 of the justices were going to be. Justice Kennedy had invited this challenge. Justice Gorsuch, now Justice Gorsuch, wrote on this case when he was a judge at the 10th Circuit. And Justice Thomas has been openly skeptical of the Dormant Commerce Clause. So we felt pretty good about 3 justices going in. I guess I was very pleased to see Justice Ginsburg take such an active role in pushing her colleagues to remember that this case is about a legal issue. I think the other side did a very good job about throwing a lot of facts at this case and trying to gum up the works, but she kept reminding her colleagues to come back to the basic legal issue. So one of my takeaways was, don't mess with RBG. She really, she very, very consistently gave that message, and also reminded me of a good Shakespeare quote, today being Shakespeare's birthday. Though she may be little, she is fierce. And so she was, I thought she did a very strong job in terms of performing that function for the court.
Andy, what were your thoughts?
Well, it is an interesting case, and the law is important, but of course, it's a really interesting case because the court is being asked to overrule precedent not a precedent that it's never addressed, actually a precedent that it's already refused to overrule once. So that's a pretty interesting situation. And it's unlike the typical situation where there's a constitutional ruling where the court has the last word, because here everyone agrees, and it's because it's true, that Congress can enact a statute that changes the rules from what the court adopted originally in Bellis Hess and reaffirmed in Quill. So this is a lot more, although it's a constitutional ruling, it's a lot more like statutory stare decisis. And I thought it was interesting for that reason that I guess I had sort of the converse view from Deb, which is it was interesting to me that the court was quite focused on whether that pretty high standard for statutory stare decisis was met, which indicate for overruling was met, which really turns on, are there changed circumstances, has there been reliance, real world facts about what the implications would be of the court overruling this, rather than leaving the decision of what to do next to Congress. And it seemed to me that everybody was very focused on that question, and obviously there were somewhat differing views, lots of differing views in the briefs, differing views on the bench, but lots of concern. I was glad to see, since the brief we filed was actually on behalf of eBay and 51 small businesses, a lot of concern about what the impact would be on small businesses if the court simply overruled Quill and left the states to do whatever they wanted.
Tillman, thoughts?
Well, kind of piggybacking on what Andy just mentioned, my takeaway was this stare decisis issue as well, particularly insofar as they were wrestling with the issue of, do we treat this as something more like akin to a constitutional stare decisis or a statutory stare decisis, since it is something, as Andy mentioned, that Congress can simply overrule itself, but on the flip side, it is something that Congress did not create in the first place, unlike a statute. And so it was somewhat unique in that respect. And there was a really heavy focus from, particularly from a few judges, on should we just let Congress handle this? And then depending on which side the justice happened to be on, seemed to suggest, yes, we should let Congress just decide what to do with this, or, well, since we created this problem, it's our problem to resolve.
Aaron.
Yeah, I'm not sure I have any reactions that are all that different from what's already been said about it. I think one of the interesting dynamics that you saw at work among the justices was, the questions seemed to be coming less from any particular kind of ideological or judicial philosophy place in terms of how they think about the doctrine here, and a little bit more about how they think about the role of the court here and the role of Congress here. And you had kind of one strain of questioning that was very much, look, why don't we clean up our doctrine and leave this to Congress, and then they can decide if they want to do, that they can still do something later if they want to. And I think you got some, and I think some of that was coming particularly from Justice Ginsburg, and then on the flip side, you had some justices like the Chief Justice and Justice Alito, who seemed to have a little bit more of the philosophy of, look, Congress could do something about this, and they haven't, and why should we overrule precedent? That's a really big deal for the court if all this can be fixed without us taking that step, and so it does, make. It makes for an interesting and unusual case when you have kind of not a whole lot of discussion about the actual precedent and a lot more discussion about who's the right person to just sort of deal with whatever problem there may be here.
Eric, thoughts?
No, then I don't have too much to add. I would say one interesting thing is that it's one of the pathologies of Quill, which is itself just a raw act of judicial policymaking, that you end up doing a lot of judicial policymaking when you're talking about getting rid of it. And so you have questions like, is this going to be good or bad for small sellers? What should the right threshold be? How are we going to draw these lines? And all of those could be criticisms of having had a judicial rule about these things in the first place. And in fact, as I think Aaron was saying, there was zero effort to defend the actual physical presence rule as anything other than a constitutional absurdity, right? Everybody took as their premise that the rule was wrong, And then the question was, what should we do next? Did you not say that it was wrong?
I mean, I am on the respondent side.
Well, I mean,
She did write a whole brief
And
about
I
the
actually
law.
wrote a brief all about the law.
But even the
We'll talk more about
even the respondents didn't spend any of their time trying to say the physical presence rule is the right rule. The Constitution, if we were starting from scratch, the Constitution would have suggested that this was the requirement. We spent time instead talking about, okay, we've done this, should we undo it?
Well, let's get to that point, because I think with a group of lawyers in the room and hopefully watching online, we've invested a lot of time and effort in putting briefs together. I want to get the arguments, frame the arguments that your respective clients made to the court. Andy?
Well, we made a lot of arguments. The principal focus of our brief was the burden on small business if the Supreme Court just pulls the plug on Quill, and what that means to many small sellers. The reality is, as I think we showed in our brief, small online retailers would immediately be subject to a number of very significant burdens. There's a lot of talk about how, don't worry, it can all be solved with the miracle of software, but the problem is, sure, software can tell you once you know what your product is and how it's classified in a particular jurisdiction, what the sales tax consequences of that might be for that particular jurisdiction. But the trick is, how do you classify the product? And so Eric is smiling because he knows what I'm going to say. So in Minnesota, for example, there's different tax rates for baby blankets and regular blankets. And in Chicago, there's a different tax rate for Snickers bars and Twix bars. So it doesn't really help to know that your buyer is in Chicago. You've got to know all the intricacies of the Chicago classification system. And if you're a small seller, we had some data on the number of jurisdictions into which small eBay sellers sell, and it's a very large number of jurisdictions where they would have to know the rules, and it's doubly a problem for small sellers who are in the craft-like business. Etsy has 1.9 million sellers, who many of whom are making handcrafted items that have yet another round of special rules. So big burdens on classification, big burdens on auditing. States will tell you, don't worry, we don't really care about small sellers, we don't audit them, but lots of stories about tax audits of small sellers. It's one thing if you have one state auditing you and you're a small business, but it's another if your customers are in 20 states and 20 states decide to audit you. Those are very, very big burdens. So a lot of stuff about the burdens of small business. We actually did talk some about the law and how those burdens relate to Commerce Clause, pretty settled Commerce Clause jurisprudence about burdens on interstate commerce. The court really hasn't moved away entirely from those doctrines. There's been some skepticism expressed, and Erin, she will talk about in her brief, had another way to think about, conceptualize the reasons why those burdens might violate the Constitution. But that was basically the thrust of our brief. And so the bottom line was, just taking away Quill means, although people might think South Dakota had been very generous in adopting a minimum protecting small businesses whose sales fall below a certain threshold from the burdens of South Dakota, there was not, once Quill was overruled, South Dakota and every other state could say, too bad, we don't really want any small business exclusion at all, or set it at a particularly low level. South Dakota's, for example, is at a low level, so if you're an Etsy seller and you sell 200 potholders or 200 separate transactions into South Dakota, you're subject to tax collection in South Dakota. So even something that seems low may not be really low when you're talking about a small seller, and those are sort of the archetypal situation of judgments that Congress can make, should make, probably, but the court can't make. And so just saying Quill is overruled opens the door to all of these consequences. And another consequence that we talked about in our brief, which is retroactive taxation, because the arguments that Quill could only, an overruling of Quill could only apply prospectively, I think are just wrong based on the court's jurisprudence. And so a really serious problem for big and small sellers that states, based on the laws they have on the books, could go after states for hundreds of millions of dollars, go after sellers for hundreds of millions of dollars in retroactive taxes, which obviously would be burdensome for everybody, but particularly burdensome for small and medium-sized companies.
Tillman, how do the state and locals react to that?
Yeah, well, the state and local legal center brief focused primarily on the burden on states and localities from not being able to collect taxes from organizations that are outside of the state, and the damage that that does to the state and local coffers and their ability to fund things like roads and health, schools, and all the things that states and localities fund. We also provided some insight into the downstream effect on small businesses that have brick and mortar within the state, and the fact that they are facing a discriminatory tax situation whereby an out-of-state seller of perhaps potholders can sell those potholders to people within the state at the same price, but at a lower cost, because then the in-state seller has to then collect the tax and remit the tax. We also discussed doctrinally the history of the physical presence doctrine and how, in our view, it does not really fit with complete auto, and that there wasn't really a particularly great reason to depart from complete auto and to create an enhanced nexus test. But even if an enhanced nexus test is required, that it should at least be based on economic activity as opposed to physical presence, which might have been a decent proxy 26 years ago, but not so much anymore.
Aaron, Andy's highlighted your innovative arguments in your brief.
Sure. So one of the things that's interesting and a little unusual about this case is if you pick up and read the briefs, I mean, that they really are, largely policy briefs, which is sort of understandable because we're dealing with a question that has a lot of policy wrapped into it. But what we tried to do with our amicus brief is to step back and say, well, let's stop and think about what the actual constitutional question is in this case. And it in a simplistic sense, it's about taxes, but it's actually a little different even from that. I mean, the ultimate tax power here is not a question of imposing taxes on somebody who's selling the products. It's about imposing a tax on the person who's purchasing the products, and then conscripting the seller into the role of collecting taxes for the state from the end user, who are the purchasers who don't voluntarily pay them unless someone makes them most of the time. And so really what's going on here is an effort by states to get private parties to essentially act as state tax collectors for them. Now, that may be something that happens within states and is something that states have the power to do with private entities that operate in their states. But here we're talking about states doing it extraterritorially and conscripting out-of-state sellers that are not in the state and have really a very indirect connection at best through kind of internet presence into that role. And so what we did in our brief is really kind of step back and talk about how there are numerous constitutional strains of thinking under the Dormant Commerce Clause, under the Due Process Clause, under other clauses that all kind of establish this principle that's one of the structural constraints in our Constitution about the constraints on the power of one state to reach out and regulate the citizens of another state, and to encourage the court to stop and think about the implications of its ruling here for broader questions about the power of states to regulate extraterritorially, and to think about that both through the lens of Commerce Clause doctrine, which has a particular doctrine that's focused on the notion that states can't regulate commerce extraterritorially, and to think about it through the Due Process Clause, through the Import-Export Clause, through other aspects of the Constitution, that if you're really going to step back and think about all this as a matter of first principles, let's think about all the first principles, not just the first principle of who had the better of the argument in Bellis, Huss, and Will, and think about, as a matter of first principles, under our Constitution, is it permissible for states to conscript out-of-state retailers into this role based on this limited kind of indirect role that we're talking about here. So it's a little bit, it's definitely a brief that is very much more focused on the underlying constitutional principles here, given that there's many briefs that do an excellent job of focusing on the policy implications.
No, it's very, very impressive. It was good to read. I'm certain, Eric, what was South Dakota thinking when they passed this legislation?
Yeah, I mean, there's a lot of arguments, obviously, in the party's brief because it's the party brief and it has a lot to cover, in part because there is so much policy in the case. I think one of the overwhelming themes of the briefing for the state is to try to remind the court that it's not talking about whether there should be burdens on small businesses or what the consequences of the various rules are going to be. The question is the physical presence rule any good at doing all the things that we're focused on? So, you know, if you're worried about small sellers, South Dakota's statute has a carve out for anybody who sells less than $100,000 or 200 transactions in South Dakota. That scale to the national economy is 75,000 transactions a year or $25 million in sales revenue. So those are big companies. And if you're worried about small sellers or big companies, you should like South Dakota's law and not a law like the physical presence rule that says if you have an independent contractor in the state for 2 weeks this year, you might have physical presence and you have to collect on everything. So, you know, the defenders of the physical presence rule aren't really defending the physical presence rule. They're just defending a status quo in which some number of retailers, whoever they might be, get this random carve out where they don't have to collect sales tax. You know, and the constitutional rule requires a nexus between the activity that's taxed and the state. And one other thing we really tried to focus the court on is, look, South Dakota is not trying to regulate extraterritorially. They don't care what you do in your transactions with New Yorkers or Californians or Mainers. The law only applies literally to transactions with South Dakotans where you're going to send something into South Dakota. And if you don't want to comply with South Dakota's rule, which is the same rule that applies to its own sellers and everybody else who does business in the state or happens to have the misfortune of stepping foot in the state physically, then you have to follow that rule just on your transactions with South Dakota. And in every other setting, for every other tax or regulatory burden, that would be assessed under Pike and Complete Auto, which are these balancing tests that actually do address how burdensome it is on out-of-state sellers, rather than the bright line physical presence rule. We were just asking the court, we tried to remind them to apply to this law, or this area of the law, the same rule it applies to literally every other area of the law challenged under the Dormant Commerce Clause.
Deb, your clients are the different cohort of the business community. What's their take on it?
Yes and no. We represent retailers as well, and we had 20 plus retail associations sign onto the Retail Litigation Center brief. So in contrast to what Andy was saying about some of the small sellers small companies who sell through Etsy, we had, for example, Bradley Graham from Politics and Prose up the street, who wrote about the challenges that he has when people walk into the store. They ask their salespeople about, you know, what's a good read? I like this kind of book. You know, what about this kind of book? And then, you know, while they are standing in the store, they pull out their phone and they can order the same exact book from another source, and they don't have to pay the sales tax. And it's or they're not obligated at the time of the transaction to pay the sales tax, even though it's owed. And that's, you know, a smaller delta for something like a book. But if you are selling a big screen TV, or if you are selling a leather sofa, or you are selling a treadmill, the differential in terms of you know, remitting the tax at the time is significant. And Justice Gorsuch pointed that out during his argument. Why should we favor one type of retailer over another? Why shouldn't we just level the playing field, remove the judicial policy making to which Eric referred before, and then, you know, let the market play out? So there were multiple different themes in terms of the Retail Litigation Center brief. That was certainly one of them. If you're going to look at small business, look at all small business and look at what your current rule is doing in terms of existing small business. And I think another theme that maybe hasn't been brought out as much is, you know, in terms of the amount of change that there's been over time. And although, you know, Quill used physical presence as sort of a shorthand, they weren't comparing it to whether or not there was e-commerce or virtual presence. when the court wrote Quill in 1992, that was 2 years before Jeff Bezos started selling books out of his garage. So really things had changed. Bellis Hess was about catalogs, Quill was about catalogs, e-commerce wasn't even a gleam in anybody's eye when Quill was written in 92. And so now you can have retail being pervasive in a much more ubiquitous way than you could by just having like a store on Main Street. Today's type of e-commerce is everywhere all of the time, and so that type of access that somebody has is very different. So our brief focused on really how much the times had changed in terms of commerce.
I think you're sensing, picking up some of the push-pull that was at play in this case and was making it a very consequential case. One of the other issues that I hope you're picking up from our panel is that overturning precedent is rare, and that struggle with that option was on display last week. On one side, you had Justice Sotomayor, who was, I want to get this right, concerned about the many unanswered questions that overturning Quill could create that could lead to a massive amount of lawsuits. In some ways, Andy, I think that's back to the parade of horribles that I think your brief highlighted on. Alternatively, Justice Ginsburg explained that if time and economic realities have rendered Quill obsolete, why should the court, which created the doctrine, let Congress fix what turns out to be our obsolete precedent? Both are reasonable arguments. Eric, you work for two justices. I want to start with you. What are your thoughts on where the court is, where this court is on stare decisis in this case?
I mean, as I was saying before, I think stare decisis is all the sport in the case. If the South Dakota Supreme Court had come up with this rule on its own, I don't know that there would be any votes for the physical presence rule on the Supreme Court. This is about, what they're fighting about is whether they should keep it, having embarked on this road a long time ago. And, for what it's worth, I think this is a place where the interesting doctrinal question, I think South Dakota has good arguments that whether you want to apply the statutory standard or the constitutional standard, times have really changed since Quill. The main issue we're talking about, e-commerce, is not something anyone even conceived of at the time. But the interesting doctrinal question, I think, is whether you would think about this properly as a statutory case or a constitutional case. There is precedent that says that you should think about it as a statutory case. It's just that precedent is Quill, the case that they are reconsidering. And so that's sort of the interesting, I think, hard question. In my view, when the court makes an error and changes the default rule in Congress, it changes what will happen, what the state's powers will be if Congress does nothing. That's the court's responsibility. It's changed the framers' design for the Constitution. If it believes that it made a mistake in changing that design, it should think of that as a constitutional error and analyze the stare decisis concerns in the way it would for constitutional cases. There is a real argument on the other side that the reason they have a different standard is because of whether or not Congress can do anything about it. In constitutional cases, sometimes the court is the last word. I think the better argument is the first one, in part because there are lots of constitutional cases where they apply constitutional stare decisis, where Congress could do something like repeal the unconstitutional law, and they still apply their constitutional rule. But this is a close issue. I think it's the doctrinally interesting one, and you can see the justices fighting about it. I'm curious to see where it comes out.
Aaron, what are your thoughts?
Yeah, I definitely do think that was an area of some disagreement on the court. From my perspective, if you think about the justification for the idea that you think that you treat stare decisis differently in the constitutional context, it's because Congress can't change it, and that justification just doesn't apply in this context. But I think stepping back from that particular question of the right stare decisis framework to apply in this case, I think one of the reasons that the court was focused on this, and one of the reasons that it's always an uphill battle when you're in a context with stare decisis, is mean, the court gets asked to overrule lots of precedents. If you take this term, for instance, the court's being asked to overrule lots of precedents, and probably, you know, some of those will be overruled, some will not, and probably in each of those cases, it's not going to be a unanimous decision about which ones you want to who wants to overrule and who doesn't, because it, you know, tends to turn on who likes the precedent and who doesn't, and that depends on which precedent you're talking about. So when you have, you know, I think that part of the reason the court would care a lot here about that question is because anything you say about stare decisis in one case can impact stare decisis in another case, can support your views of it in another case, or you know, in the alternative, kind of be thrown back in your face a little bit in another case if you're saying here stare decisis is a big deal and here it's not. And you know, so I think part of that dialogue is one of the things that's always interesting to watch with the court, that anytime they're dealing with any one case on a given day, they also have lots of other cases in their mind that they are struggling with throughout that year. And you know, I suspect that some of the thoughts about how stare decisis might play a role in other cases throughout this term were in the forefront of the court's mind as the justices thought about what role they think it should play in this case.
Deborah, what do you think?
Clearly, stare decisis is the 800-pound gorilla in the room for sure. You know, in this situation, though, the doctrinal underpinnings are so narrow that the court really can say, boy, times have changed significantly. And Andy talked about this as, you know, a case about overruling a case that had already been affirmed. But you're talking about the original precedent is from 1967. And in that case, the court said, you know, without they're both due process limitations and Commerce Clause limitations on whether a state can require a remote seller, in that case, a catalog mailer, from collecting and remitting the tax, right? So those are the days when you get the paper catalog and you're looking through the catalog and you're writing a paper check, right? Probably unrealistic. By 1992, the court's doctrines had changed some, and so there was a challenge mounted to that. And by another catalog mailer, and the court very, you know, narrowly, well, it was an 8-1 decision, but most of the justices didn't like it too much. They overturned the due process holding, and they said, well, we're just going to hold on to this Commerce Clause prohibition because we think there still might be some problems in terms of catalog mailers being able to require, being able to collect and remit the taxes being owed. But you know, you go back and you look at that decision, Justice White was the only remaining justice from the Bellis Hess Court. And he said, you know what, we got it wrong. Like, I'm going to paraphrase because I'm not a constitutional lawyer, but he said, you know, my colleagues just didn't have the nerve, but they should have just overruled the whole thing and uprooted it entirely. But you know, it was an 8-1 decision. It's still on the books, but it was those are the two basic decisions that are out there. Other than those two decisions, court hasn't acted in this situation. They certainly have never ruled on e-commerce and states' ability to require remote e-commerce sellers in this day and age to collect and remit. So I think that does change the calculus to some extent, notwithstanding the fact that yes, the court is thinking about a lot of things and overruling them, and that does put a different gloss on it.
Tillman, how are you going to present this to your students when they ask you about stuff?
Well, of course, it depends on how the court comes out. But if and I would hope that the court would expressly recognize that this really doesn't fit into either of those boxes because it's not a statute that's been interpreted, and at the same time, it is a constitutional issue that can be relatively easily, not in a practical sense, but in a doctrinal sense, relatively easily overturned by Congress. And so I would like for them to acknowledge that this is just a different animal and that it has no precedential value with respect to the other potential overturning precedent, particularly given the fact that, you know, under the Dormant Commerce Clause, and this is one thing that's kind of bothered me about this, well, shouldn't we leave it to Congress question, is the fact that striking down a law under the Dormant Commerce Clause is inherently not leaving it to Congress. And so, you know, even if it's based on a prior precedent, that prior precedent was inherently not leaving it to Congress. And so I will present it to my students as one in which in which they hopefully will get to see that there are a couple of competing doctrines here on how to handle stare decisis, but that doesn't necessarily mean that every case in which overturning a precedent is presented needs to fit into one of those two frameworks, given the fact that the law at issue here doesn't fit into either framework.
Andy, you get the last word on this.
Well, I'll say a word about stare decisis and then turn back to your question about what Justice Sotomayor was concerned about. It just seems to me that this case is most parallel to a case that the court, in which the court refused to overrule precedent just a few years ago. In the Halliburton case, the question was, which was a case about 10b-5 liability under the securities law, where the court has not only invented the private cause of action using a doctrine that has been totally disavowed, but also went on to invent a doctrine of reliance, or a way to sort of get around the requirement of reliance that I think would not stand up under today's precedent. And the court asked to overrule the basic case, which is the case that adopted this sort of fraud on the market test for reliance, said, well, you know, this is a question of stare decisis. Congress has visited this area. Congress can change the rule if it wants to. So even though both the underlying cause of action and this particular legal rule aren't things we would do these days and are beyond the judicial role, we're not going to overturn them. And I think that is a very strong analogy to what's going on, what should go on here, which is, sure, we can debate about whether or not the underlying constitutional rule would be adopted today, maybe would be adopted under a different heading, the way a different fount of constitutional doctrine, the way Aaron suggests. But it seems to me, because Congress can act, it's very similar to the Halliburton case. But let me turn back to the sort of what bad things could happen, because I think one of the things that I find very sort of surprising and concerning about how the briefing developed, and this is especially the brief filed by the Solicitor General actually, is this idea that there's something called web presence that allows states to regulate an e-commerce seller or maybe even an e-commerce site just because it's accessible by the people within that state. I had the privilege in the late 1990s in working in the government at a time when e-commerce doctrine was just developing, including serving on a commission that looked at this very issue in 1999. But US policy was very clear that e-commerce and the internet generally is this wonderful tool. And if you say that any place where it's viewed domestically, and even more importantly internationally, can regulate what's on that screen or what that seller does, you are really going to strangle e-commerce. And so I think the idea of differentiating, saying that e-commerce is subject to more regulation than catalog sellers is a sort of a frightening concept. And the SG's office takes it to the degree which basically says, if your website is accessible, then the jurisdiction that it can be accessed from can regulate it. And I think that is a dramatic change from US policy, both domestically, but even more importantly internationally, that has tremendous adverse consequences for e-commerce. So that's one issue that I just wanted to lay down. And one of the things that Congress has done in this area actually is to enact a law that says you can't discriminate between online selling versus other kinds of selling. So the one thing Congress has made clear is it really didn't want to allow that kind of discrimination. So I think the argument to the court that you can leave Quill in place with respect to catalog selling, but create a new rule for e-commerce selling is diametrically opposed to one thing that Congress has done in this area. But sort of talking about the consequences, you know, we've talked a little bit about small business, and I think the reason for the focus on small business is because even since Quill, or maybe even since Justice Kennedy wrote his concurring opinion in the direct marketing case, there's been a significant change in the world of online selling, which is more and more online selling is being done by large companies that are either brick and mortar companies that have migrated to the online world, think Walmart, Costco. Online companies that have migrated to the brick and mortar world, think Amazon, or a whole bunch of websites that now have physical presence and therefore are collecting taxes under the current rule. And a big change, therefore, in the percent of online commerce that is under current rules accessible to the states in terms of being able to require tax collection. So it really does come down to, if Quill is overruled, we're focusing for the most part on the burden on small and medium-sized companies, which is why I think the court was concerned. And the problem, whatever you may think of the South Dakota rule, is there's nothing to prevent South Dakota or any other state from adopting a rule that doesn't have any protection for small sellers. And that is the state of the law, you know, in most places right now. So I think that's the concern. There's another big concern out there about what happens that I don't think that Justice Sotomayor adverted to, but since we're in a law school, I feel like I have to mention it, which is selling of services remotely, providing services remotely. Service providers have been protected by the Quill rule. If you don't have a physical presence in a state, if you're, let's say, a lawyer providing services to an out-of-state client, that doesn't involve you going to the state or appearing in the state, which more and more true these days, you are not subject to tax in that case state. And as a result, many states have not adopted services taxes. But if there's no physical presence rule, lawyers, architects, engineers, online services like providing music, you name it, streaming will all become subject to taxes all over the place. And you know, maybe that's fine for big companies, but that's obviously creates a big burden for small companies. And I think that is another thing. So if you think about retroactivity, what to do about small businesses, services, those are all things that Congress can address in a tailored way. And I think the gist of Justice Sotomayor's question, what she was getting at was, those are all things that Congress can address in a tailored way, and the Supreme Court can't. It has an on-off switch. And even if you think, and we certainly tried to preserve this issue in our brief because we're concerned about it for our clients, that the due process clause might provide some protection for small sellers, what do those small sellers do the day after Quill is decided? There are laws on the books in I think 20 some odd states that would automatically require sellers to comply with state collection and remittance laws. Maybe in 5 years, there'll be some test cases where we know whether there is due process protection for small sellers or not. But in the meantime, they face draconian penalties for not complying. So the idea that there might be some further litigation about how far South Dakota could go or whether there's other protection doesn't really give those small sellers any comfort about what they do on July 1st.
Eric,
David, with permission, I have a dead horse that I would really like to beat, if that's okay. If you're worried about problems like the service problem, just recognize that like the physical presence rule doesn't require a relationship between the service or the thing being taxed and why you're physically present in the state. So if you happen to travel to South Dakota once during the year to provide lawyering services to one client, then every single time you sell service to any client in South Dakota that year, maybe the next year too, you have to figure out what South Dakota does to tax lawyer services, what the rate is in each town where you're providing the lawyer services, and you got to sort all of that out, right? And in fact, that's the rule today, because South Dakota does tax services, and I had to register for a sales tax license when I went to provide legal services there. It turns out the state is exempt, so we didn't pay any sales taxes, collect any sales taxes, but there it is. You know?
But I think that's a critical question, which is, and that's why I sort of disagree with your thought about this being random. It's not random. The question for the court is reliance on the existing rule. Are there reliance interests that have been built up? That's a critical question on stare decisis. So whether or not it's the rational rule that we all would pick if we were, you know, in some rational drafting place, if you're a service provider or a seller, you know, guess what? The trigger is physical presence. Yes, once physical presence happens, maybe the tax consequences are not ideal, but you know that there's that trigger, and lots of people order their affairs based on that fact.
Yeah, no, for sure. I'm just saying, I mean, I think you were saying in the future they might do people might do services too. States haven't tried to do it because of the Quill rule. I think nothing is stopping them from doing it now. right?
Well, you'd still have to get over physical presence, though.
Right, but you know, most people end up physically present somewhere.
I don't know. My clients never want me to visit, so.
Yeah, three other panelists. Do you want to jump in on this before I get to the last question?
Do we want to ask people
Yeah, I don't know.
questions?
I've got time for one question because I've got one more here. Right up front. Name and where you're from, please.
Jeff Krasny. I wrote my tax thesis on Quill many years ago from this university. I'm curious if the 10th justice in the room who died about a year and a half ago might have some remnants of within this case. He basically said, again, he talked about Reliance, he talked about Acme, and he talked about stare decisis. How much within his concurrence within Quill? So I went into the oral hearing thinking that it was going to come out one way. With the questions that were addressed, seemingly I came out a totally different manner. Specifically, once Judge Kennedy asked his two questions, and once Mr. Isaacson responded to Justice Kennedy. So my question, I guess, to you is, again, the Reliance aspect or the aspect of Acme from Justice Scalia, how much is that going to continue? And if so, if it does continue, is it too early to write Quill's epitaph at this point?
You all get to answer that? I mean, I think, you know, that there's a powerful reliance argument to be made, and it helps that it was made by Justice Scalia the last time this case was before the court. That was mentioned during argument a few times, and you know, I think that it matters that it was, you know, in that opinion from him that approached it and said this is a real serious issue, particularly because, you know, everyone knows he was no friend of the Dormant Commerce Clause. So, you know, for him to say, look, I mean, he does have an interesting note in his concurrence about maybe if I were thinking about all of this from first principles, I might, you know, have a little bit different view. But setting that aside, you know, for somebody who generally, you know, did not approve of the court's Dormant Commerce Clause jurisprudence to be the one who wrote a concurrence saying, look, that this is one of the, you know, this is such a context in which reliance should carry the day. You know, I mean, I think that is something that probably impacted some of the justices that were focusing on that aspect of the case.
Deborah, did you want to?
Yeah, I'll just add, I mean, that's on the legal aspect, but if you think about it from a practical perspective, the reliance interest is in people not paying their taxes, right? The Wayfair, which is one of the three defendants, advertises on its website, one of the best things about buying from us is you don't have to pay, you know, we're not going to collect the sales tax. And so,
advertised until you pointed that out in
that's
the brief.
true, advertised until we pointed out their brief. We think they've taken it down from their website now, but it's still in our brief. But in any event, so to the extent that the reliance interest here is the practical reliance interest of people not being willing to pay their taxes that are owed, so that it looks like the price is being charged or less, we don't think that's a valid reliance interest in the first place.
Can I say something about that? Because I think that is a real red herring.
Yes, you may.
First of all, it's not their taxes.
Right.
Second of all, the reliance, there are two different packages being sold. An online seller doesn't collect sales tax if there's no presence, but there will be a shipping charge in most cases, or that shipping charge won't be separately stated, but it will be built into the sales price. There will be an inability for the customer to see and touch the good, whatever it is, from that person.
We'll do it in our store.
Well, can I finish? Then there also is the inability to get quick and convenient service if something goes wrong. If I buy something from the store down the street, I can go down the street when something goes wrong. Online, it's a much more complicated problem, and I've certainly had that problem. The in-person person may collect sales tax, but there is no shipping charge. They do have an in-store experience, and there is a convenient location for service. So the idea that this is reliance on tax avoidance, I think, is just not true. It is a business constructed on the business not having this burden And the business has other burdens. So I just really sorry to get excited, but I think that is a total red herring. And even whatever you think about Wayfair, I don't represent them. When you are looking at small and medium-sized companies, it is a real red herring.
What item that we haven't talked about is the parallel here of sales tax and use tax. And I think we all are familiar with what a use tax is, and I'm certain everyone in the room pays their annual use tax. So we'll hold it at that, since I'm the moderator, I get to close and come to the wrap up of the final question. Rapid fire, since we're on 2-minute notice here. It's imprudent to ask the question that's not going to stop me. And the question is, predict how the court's going to rule, who writes, and what's the final tally? I'm going to start with Eric at the end. We're going to work our way down.
I think that the court is going to uphold the South Dakota law on narrow ground, saying that it's reasonable, but it doesn't want to make a decision about what the reasonable minimum would be. I think that will be if we come to that view, it will be because the chief wants it, and there'll be probably 6 votes for it. And I think it probably gets assigned to Justice Kennedy.
To Justice Kennedy. Deborah?
Yeah, I think, I also think the South Dakota law gets upheld as constitutional, and I think Justice Kennedy writes.
Andy?
I think probably no one's going to disagree with their client's position. So I think, but I also think that the court will reaffirm Quill and say, this is there are reliance interests here, Congress can act, Congress has been considering what to do, and we're going to leave all of these complicated consequences in the lap of Congress.
You know, I think the same thing. I think it's going to be, I think we'll survive. I think it'll survive narrowly. I think it's going to be an interesting lineup of justices if based on what they asked at argument, they are where they all appear to be. And I think if it's the 5-4 that I think it's going to be, maybe Sotomayor gets the assignment.
Tillman, last word.
I also will not disagree with my client, and so I think that the vote will come down overturning Quill, adopting an economic nexus test. I'm going to be so bold as to even go 7-2, though I think 3 of those votes could go either way, and I will pick Justice Dakota Wright.
Excellent. We've come to the end of the hour. Special thank you to our panelists. I also want to thank Georgetown Law School for hosting today, as well as the Native American Law Students Association. And thank you to everyone in the audience and to those that are watching and will watch this on tape delay. Appreciate it. I'm David Parkhurst. Thank you.
They're always sticking Justice Alito
So it covers kids cases who doesn't want to write.
I don't think he's written this one. All the predictions I believe he's made. That's one.
It's great. Excellent for coming out here.
I don't see how they can do it. This is another thing I don't understand. If they overrule
The rule is made up, they can do whatever they want.
but zero other cases. But changing the rule requires, I think, people who think the Commerce Clause project is unjustified. He's not going to sign on to. He's not going to say, "Oh, don't worry, like balance interests." I don't think he's going to.
They can just say they can do literally anything. It won't affect any other area of law.
But it affects this area of law. I think it's illegitimate.
What
As
area
an
of law
initial
state sales and use?
If they think it's illegitimate as an initial they're not going to sign on to an opinion that says, "Oh, we're now going to go further in drawing."
It's such a funny defense. We have a very arbitrary rule. This other one would be also arbitrary. So we're stuck with this one.
Well, if Congress couldn't overturn it, I think it would be much stricter.
But I just in the middle of that the whole time.
But I think it's hard. I think it's very, very hard not sign to make that one.
So let me ask you, this is the nuanced question.
He's one of the 3 that I think could go either way. I think he's with two of them.
Because Congress
I think we'll go with economic nexus.
Because they can't write a statute that says,
they can write this this act is hereby repealed.
Like I said,
But they can't do what they want to do. They can't put in place
the existing rule is
So I got to stop that for you. We'll see.
All right, well,
You think that's
right?
Congress can fix it. They can repeal the statute.
All right, thanks for coming,
Right.
Deborah.
So should more change
Native American laws.
Oh, we
because
didn't
the
talk
question
about
is,
your
if the
the
court
Native
says
American
Congress
brief at all.
Yeah, I know. Well, it was kind of a neither side.
Sorry,
Right.
if the elected branches
Take lots. Everyone's concerned about that.
Right.
Why is it not
Well, maybe
I was telling them
Marston
that
against
forces I worked outside there at 5 a.m.
Right, but
Which you said.
Oh, you didn't get in?
Yeah. Well,
then obviously,
like I said,
I got it in 3 minutes.
Then I guess
I got to see sort of my own.
don't you think this has to be a both ways kind of rule? I don't think it
My
can.
daughter
that's a good point.
My daughter was there. She was there at 5:30 when I managed to get her. I did admissions and submission, so it's
We're very
passes.
don't believe it all.
Yeah, would you listen to the audio?
I will next week when my final term.
Oh, yeah. I saw right last day.
states are free to take
There was a
positions
little sheet in the elevator last day classes coming up.
Yeah,
They're not
enough
So that's
there.
good. Are you a 3L or are you almost
How
done?
much real joint treaty impact?
Oh,
And it's not just states that repeal it.
I understand the state, and, you know, I guess we'll see.
And what
You know, we'd like to have legislation, and if all of the big states were not their clients, would be willing to make a deal, that's the best way to solve it.
But I think you could put
This
bring
has
to
been
bear a lot
near
of
and dear
pressure
to my heart for a long time.
Amazon's
Legislative
without
side.
any
So I actually coordinated.
I know, but if you have the change, you certainly doesn't, right?
Well, you don't have to.
Which of the two deviltry do you want? One where there's 100% certainty, or one where at least there's some argument?
Yeah, right. No, I agree with that. I'm just saying.
You know, are they totally out of the woods? No, nobody's totally out of the woods. But, you know, hopefully the states will then say,
Yeah.
maybe we actually should finally agree on something.
I mean, there was an agreement, like,
Main Street Mall.
right, majority supported.
Yeah, like $1 million protection. Just give me a break.
How about 25 to start?
So is there a way,
But that's not, you know,
make this rule?
I understand why
South
that.
Dakota, but not allow all the other states retroactively to apply the other 30.
Right. So first of all, one of the things that's in the parties brief is an appendix that covers.
This has
some
been
of
the biggest engine
laws
of
where they say
entrepreneurial
there is
growth
no
among the disadvantaged communities of anything that has happened. Veterans, women, people of color, people who are in geographically depressed area. Why should we make this like?
I totally agree. I mean, I think policy should favor small business. There's no question.
But is that an artificial benefit to the mom and pop?
So that's small
Or are they getting
Right, and they advantages not
But give me a break. In terms of comparative advantage, they still have.
Trust me, eBay and Amazon are all providing this service for free. If there's any amount of pressure brought to bear on sellers,
Well, it's going to be very hard. You know, I thought the Etsy story of Washington.
well, I didn't
In their brief.
what is it?
They tried to comply with Washington, and you know, when you have all of these handmade things, guess what? The classification problem is a really, really, really serious problem, and it's a really, really serious problem if you're one step removed from the person.
That's why the court should approve it. Streamlined sales tax meets pipe. That's all the court has to say.
Are they involved in the legal discussion?
Don't respectively, and leave it for another day as to whether or not $1 is actually an average.
These days, I do this.
I think that's necessary. Well, thanks for having us.
Thanks so much for coming.
Appreciate it. You guys speak as well.
And because the states really decided that, you know, is a very what should be so for America. But yeah, you know, great job. Thanks a lot. Thanks a lot.
Because it goes away with the
I
price.
came in thinking.
And here we are, the US government advocating very saying, well, how credible are we gonna be? Advocating against which is a dagger. I don't know what
General election territorial, website presence.
Varying sizes.
The content website presence is frightening.
It's the worst.
It's not like I disagree with them.
One transaction and one just.
And that's what I brought up.
I mean, it's just, you know.
I think a big starting point is just
whole new process.
Do you think shouldn't people
Because
rely
they do,
on what this is?
right? Then you just think,
But I don't
it's a less smaller.
No, it is. But again, I said, the purpose of starting.
That's exactly right. Yeah, well, I think we have, basically, what a ridiculous lawless decision.
Doesn't give us.
But you know what?
I mean, if we're creating a
That's what
there's no reason for this to happen.
It's
Incorrect. But again, see, I got the impression that
Yeah.
otherwise,
The
argument was still.
the counterpoint for some of those things.
It's just not.
I didn't get that you were coming, so Lisa
Thanks a lot.
told me the last time.
I know, no,
Would you mind? I just forgot it, so I will.
Yes.
Thank you.
Yes, you're coming to I'll come to yours.
Oh, great. I'll drag you out
There you go. That's good.
Things you did in your former life.
Yeah.
That's how I felt.
Thank you for having me.
6 months I spent.
Good job moderating. Any questions?
No, that's the question.
Agreed to 9 months ago.
Oh, wow. Well, good to see you. Keep your
I
fingers
was
crossed.
waiting for Justice Kennedy, I was waiting for the Justice Kennedy show. And instead, Justice Sotomayor started off first, and then Justice Kagan entered the fray, basically saying, what about Congress? Should we say Congress? And then the Chief Justice said, haven't we really deep with this point? And it's only in terms of once the respondent, if he wants, rises. Justice Kennedy said, about certain times. I just thought it was kind of really important. So, well, like back to Justice Kennedy, saying about let's focus on Justice Kennedy's and on the lines we can act in respect of Justice Kennedy didn't say anything further. And to me, that was the point where if he would have continued with his line of questioning, I would have said, okay, now it's heading in this direction, but stop. And that's when I said to myself, wow.
Well,
I'm really even from, again, that was my point, that's what I basically wrote on it. I think it was, you guys up there, seemingly in my last lunch, this is a little premature to
Oh, yeah, no, I wouldn't try and, like I said, I think there are 3 votes that could go either direction. I think 7-2, 6-3, or 5-4.
the other way.
The other way. No, I don't see a 5-4 our way. But I think ultimately the chief and the leader are going to go together. And that's why I think the leader originally had scoffs.
No, I think you're right. I think
Because I think the chief would assign it to Alito if he didn't know enough process. Or do it himself, one of the two. I don't see him assigning it to Kennedy.
if you're on the vote.
If they're on the fence, they're like, we need strong economic presence, and not just we overturn the goal and do everything as it is. I think you'd be worried that you're going to do that. So, and obviously all this is pure speculation, but I would probably.
The interesting thing about what you mentioned, there was a point where she said, it's this equalization versus discrimination. That's the vote, that's the fourth vote. But then she came back in another question that totally had a totally opposite viewpoint. And so I came out, and she's the only one that I am undetermined as to where she sides. Yeah, we will see. Yeah, no,
Nice to meet somebody who worked on this for over 26 years ago. Nice to meet you as well.
Oh, I did my tax thesis.
Amazing. That's amazing.
Yeah.
Everything old is new again.
Yeah, exactly.
Okay, thank you. I was in here earlier, so it was a great event.
You like it?
Yeah.
Cool.
Do you run NALSA?
I do, yeah.
Yeah, I thought it was really awesome. I used to have a small business, so like in e-commerce, and so I thought it was super.
Oh, okay, cool. Like a website business?
Yeah, e-commerce and catalog.
Oh, alright.
So is that what you did? Yeah. And we got like we paid like tax and flag statements.
No. Anyone cookies, anyone, before I put these in the way?
Okay. I'm okay. Thank you.
Please, okay.
Did you make them?
No,
Oh no, okay. I saw you putting it in Tupperware.